Good evening, everyone. I welcome you all to the third lecture of Constitutional Law Guest Lecture Series. Constitutional Law Society is a student-run body at National University, Jodhpur, which aims to encourage course of constitutional law. I'm really sorry through regular updates, primers, and discussions. Today, I am delighted to introduce one of the tallest and arguably best constitutional law scholar, Professor Mark Tushnet. Professor Tushnet's scholarship focuses on constitutional law and theory, including comparative constitutional law. His research includes studies of constitutional law review in the United States and around the world, and creation of other institutions for protecting constitutional democracy. Professor Tushnet is the co-author of four casebooks, including the most widely used casebook on Constitutional Law with Stone, Sidman, and Sunstein. He has written more than a dozen books, including a two-volume work on the life of Justice Thurgood Marshall, A Court Divided, The Rehnquist Court, and the Future of Constitutional Law. We welcome you, Professor, on the behalf of Constitutional Law Society, NLU-Jodhpur.
Thank you. I am happy to be able to give this talk to this group. I've been interested in Indian constitutional development for quite a while and have enjoyed my visits to India to give lectures and regret that I'm unable to do this one in person. My talk is going to be divided into three or four. So first I'm going to talk about the connection, or rather the lack of connection that we've seen between the policy responses to COVID and constitutional form or design. Second, I'll talk about how the COVID pandemic illustrates some important concepts of some important themes in the constitutional discussions of emergency powers generally. And third, one of those themes has been the idea that executive officials typically try to use the occasions of emergency to expand their power. And yet, in at least two prominent instances, that hasn't happened with respect to COVID. And I'll talk a little about what that might mean. And then finally, if there's time, I'll speculate about some other institutional approaches to dealing with the COVID pandemic. So first, on the policy level, I think the starting point has to be something that I'll put a little strongly, but captures the basic contours of what's happened. I think that the starting point has to be that essentially no one did a good job in the immediate response to the advent of the pandemic. The reason seems to be that the good policy responses had two basically components. First, if you have the capacity to do so, immediately get to work on a vaccine. And everybody with the capacity to do that did. But second, in order to cut down on the incidence of severe illness and death, what it looks like what you had to do in January 2020, just as the pandemic was arriving on the shores, was two things. First, you had to shut your borders immediately. And second, you had to lock down your economy for a period that turned out to be about 4 weeks. If you did that, you'd be able to control the arrival of the virus in your jurisdiction. Well, coming up with that particular response required either enormous luck, which sometimes happened, or incredible foresight. And that latter was just in short supply. So the only places that successfully met the pandemic turned out to be met the pandemic's increase in illness and death, turned out to be island nations who were able to close their borders quickly, and relatively small ones who could shut the economy down for 6 weeks, 4 to 6 weeks. And there are a handful of places that did that, and they deserve credit for their leaders, deserve credit for understanding that that was what was needed, or for, by chance, picking the right kinds of policies. Everywhere else, the second policy level to avoid the spread of the disease failed. And what that means is that although each of us is tempted to say, well, our nation experienced a policy failure, and it must be because there's something wrong with the policy-making apparatus in our system. Either our decision makers were incompetent, or our institutions were unable to generate competent leaders, decision makers, who would make, unable to support leaders who wanted to make the right decisions. We're all tempted to do that. We see the failure and we want to say it's a failure of our system. But because basically no one did a good job, you can't connect the underlying constitutional system or political leadership to the outcomes that were experienced. They're just, no, because nobody did a good job, every system failed. So there seems to be no systematic connection between policy outcomes and government structure. People have sort of tried to look for it in large N statistical studies, and nothing seems to do a great job of predicting, or determining what systems responded well. I think there's some hints of some possibilities, but I think at this moment, and likely in general, we're going to have to end up saying, no, this was just an extremely difficult policy problem that systems were not systematically designed to handle. And because this may have some bearing on what I'll say towards the end, we have to identify, it may help to identify the nature of the problem that led to more or less universal systemic failures. The nature of the problem was this. At the early stage, there's a great deal of uncertainty about the nature of the illness or the virus. We learned rather quickly about it, but it took 2 to 3 weeks to for the scientists to get a good handle on, in particular, how rapidly the virus would spread. And it turns out that the virus spread very fast. But what that meant is by the time you knew that you really had to shut down the economy and close your borders, it was too late. So the nature of the problem generated the policy failures rather than the government's responses. Okay, so that's my first point, that we're tempted to connect policy failures to constitutional and political structures, and we should resist that temptation, at least for the moment. Maybe scholarship will eventually show that there were some systemic relations, but so far we should be skeptical about claims about why we failed. Basically, people failed because it was a problem of a sort that made failure almost inevitable. And I suppose I should note that on the first component, developing a vaccine, everybody who had the power, had the capacity to do it, did a good job. Of course, not everybody had that capacity, but nations with well-developed pharmaceutical manufacturing industries moved quickly, and the science has reached a point where vaccines could be developed and were developed very rapidly. Okay, so there's a policy success at the vaccine level and policy failure at the transmission level, and both were predictable and occurred. Okay, now second part of the talk is about emergency power in constitutional theory. Here, the basic propositions come out of the scholarship of Carl Schmitt in Germany in the 1920s. Now, every time you mention the name of Carl Schmitt, you have to say that he was an extreme conservative who ultimately joined the Nazi Party and generated legal opinions that supported the Nazi Party's position early in its reign. He actually was expelled from the Nazi Party basically because he was, in my view, he was too smart, and he saw where they were from his conservative perspective going wrong. But he was a Nazi, and some aspects of his constitutional theory were generalized later by him into the support for the Nazis. One of those things that was generalized was his account of emergency power. And this is his most famous line in constitutional theory: sovereign is he who gets to declare the emergency or the exception. Now, he came up with that idea by examining emergency powers. And his initial formulations about emergency powers were both sensible and accurate, and don't lead inevitably to the principle that the nation's elected president, the Führer, the leader, has to have absolute power, is the sovereign. What he observed in the narrow framing was this. You can write into your constitution, or it turns out into statutes, definitions of emergencies and things that can and can't be done in the emergencies as defined. But it is the nature of emergencies that you can't describe them comprehensively before they occur. Or alternatively, when you describe them comprehensively, you will include a quite general catch-all provision, which has the effect, and so the effect of these two possibilities ends up being the same, which is eventually an emergency is going to come along where either the first branch, the Constitution and statutes, don't address the problem, or in the second branch, what they say is manifestly inappropriate given the nature of the emergency. So go back to the first branch. You can have constitutions that say the executive, president, prime minister can declare an emergency in case of invasions, widespread disorders, or and if you can list some possibilities. Or the other version is invasions, widespread civic disorders, and anything else that threatens the continuity of the nation. That's the French formulation. Well, along comes the pandemic, and it's clearly an emergency. You got to do something very fast about it. You have to actually suspend some civil liberties, a point I'll get to in a moment, in order to address the problem. And it's not adequately dealt with in what's written down. Or if you say it's dealt with, you say like, a pandemic is like an invasion. We're being invaded by these foreign viruses. Okay, you can do that, but it's not what invasion meant when it was put into the Constitution. Or again, you can use the catch-all threatening the life of the nation, but that means you can declare an emergency whenever you want. So what Schmidt said was, look, you just can't regulate emergencies through the forms of law. There have to be immediate responses that will be, I'll call it, I've used the word extra legal, or critics will say illegal, not authorized by existing law. And Schmidt said, and here he was right, you're just going to have that, you're going to live with that. You're going to have a constitutional theory that says there will be emergency occasions that require the executive to take extra legal or nominally illegal action. And then he said, how do you theorize it? And you say, well, in these circumstances, the executive is the sovereign, not the people acting through the Constitution, but the executive is the sovereign. The sovereign is he who gets to declare the exception. Okay, so now what does that mean? Well, first of all, we need to look at what constitutions and statutes try to do when they do deal with emergencies. And what they do is take two approaches. First, they specify some procedures that have to be followed. So the executive can declare an emergency, but has to have the actions ratified by the legislature within a relatively short period. And once the legislature does that, it takes over. It's got to renew the grants of authority, or it's got to renew the authorities. The executive can't renew them on his or her own. Various forms of procedural, call it ratification. Second, there are substantive restrictions. So although in an emergency, the executive can, I'll use the phrase, suspend certain constitutional liberties, in particular in the COVID context, the liberty of free movement. There are other civil liberties that the executive can't suspend, such as the standard one is prohibition on torture, but also restrictions on free expression. And importantly, restrictions on the executive can't prevent the sitting of the parliament, because if the executive could do that, it would undermine the procedural requirements of ratification. Okay, so now what do we learn from the COVID experience about these ways of attempting to regulate executive authority? Remember, the Schmittian argument is you're going to have to live with the fact that the executive is going to take extra legal action. Well, that means that there will be circumstances where the executive will not obtain ratification, or where the executive will restrict civil liberties in ways that seem to be prohibited by the substantive regulation. What's experience been? Well, first, on the procedural side, at least in the immediate response to the pandemic, essentially every legislature that was asked to ratify the executive's action did so. Whether or not, mostly that occurred because the executive had majority support in the legislature. So if you have a prime minister, a parliamentary system, the prime minister will declare an emergency, go to the parliament for ratification. If the prime minister has majority support, the prime minister's party will vote to ratify. If the government's a coalition government, the coalition will at least initially vote to ratify the actions. And so you get this sort of initial, in a presidential system where ratification is required, the political scientists have identified what they call a rally around the flag effect. Everybody defers to the president in the immediate aftermath of a declaration of an emergency. There's one, and that's what happened, basically. One qualification I'll get to in just a moment. One important, I don't know, not quite feature of this story is that the rubber stamping might erode over time. That is, president, prime minister declares an emergency, gets ratification for 3 months. 3 months expires. President and prime minister says, we need to continue these measures. Eventually, particularly if there's a coalition government, some elements of the coalition may begin to get nervous. about ratifying the president's action. And over time, the ability to rubber stamp may diminish. Some of that occurred in some places, in coalition governments in particular, around the world. Similar phenomenon can happen even if the government has a majority support. Components of the majorities are always internally coalitions, and some factions within the coalition may begin to get nervous, and the prime minister may have to do some political work to maintain the factions' dominance over the factions. And what that means is that prime ministers, presidents will start modifying the efforts that they make to deal with the emergency. On the substantive side, there are two observations I want to make. One is that the nature of the pandemic was such that a credible case could have been made for two things. First, in some nations, elections were scheduled relatively soon after the onset of the arrival of the pandemic. A credible case could have been made for suspending those elections, for postponing them. Second is, similarly, given the nature of the pandemic, a credible case could have been made for suspending at the very least, in-person meetings of parliaments. Strikingly, very little of those things occurred. That is, some presidents did, or prime ministers did try to postpone some elections. The most notable one that I'm aware of, there may be others, involved Bolivia, where there had been essentially a coup, and the election to replace the coup leadership was scheduled during the pandemic. The coup leadership, having conducted a coup, wanted to stay in power, and they did postpone the scheduled election, but their political position was so shaky that they could do it only for a couple of weeks, and the election was eventually held. Similarly, parliaments met regularly and mostly in person after the pandemic arrived. And so, even though presidents could have, or prime ministers could have, pushed hard against these procedural limitations, they didn't. And that's a point that I'll come back to in a few minutes. Second observation, I have described the actions that presidents take as restricting civil liberties. But I think one thing that we learn from the pandemic experience is that that's a bad description of what the Constitution actually protects. So this is easiest to see in systems that have express limitations clauses like the Canadian or the European, I think it's the International Covenant on Civil and Political Rights. The Canadian formulation is, here are all the rights you have. They can be limited by law, a tricky point in which I can address in comments if people want, but they can be limited by law when the limitations are demonstrably justified in a free and democratic society. And what that's generated is a set of doctrines that go under the heading of proportionality. And here, the important point is that the first step of a proportionality analysis is this. You have a right. You have that right, say freedom of movement, or freedom of occupation, to promote certain human interests. Legislation can, in the doctrinal formulation, infringe on those interests without violating them. Legislation infringes on those interests by making it more difficult for people to exercise freedom of movement or freedom of occupation. But the mere fact that there's an infringement doesn't show that there's a violation, because infringements can be justified by later steps in the proportionality analysis. Now, you don't have to buy the full level, the full form of proportionality to understand what's going on here. What's going on is that we need to distinguish between things that make it laws that make it more difficult to fully exercise the values, fully advance the values protected by constitutional rights. We have to distinguish between laws that do that and laws that violate the rights. So restrictions on movement or occupation adopted in the course of the pandemic do infringe on those rights. They make it impossible to fully advance the interests protected by the rights. But they shouldn't be described as violations, or at least they shouldn't automatically be described as violations. You have to think about whether these infringements are ultimately justified. And here I get to the final component of this second part of my talk, which is the role of the courts. Now, mostly courts have gone along with what executives have done. They're part of the rubber stamping process. They do it under the guise of saying, well, there's executive discretion here, and the executive's discretion wasn't abused. Sometimes, and I'll talk about this in the third part, they say, actually, the executive did abuse its discretion in a pure kind of way, but mostly, I want to emphasize, when they tried to intervene on these procedural, you shouldn't have declared an emergency grounds, their opinions haven't been terribly persuasive. Second, what about the rights protective aspect of courts? Well, here courts have behaved better, but not have acted better, but not, in my view, overall terribly well. Here I may be generalizing a bit too much from the US experience, but I think this has occurred more generally around the world. Courts have said some of the restrictions on liberty that you've imposed are unjustified. Now, there are two variants of that. One where courts, I think, have been okay is to say, look, this regulation is completely unreasonable. You haven't come up with any decent justification for what you're doing at all. You've singled out some people or things for regulation, but other people and other activities are just like the ones you singled out, and you haven't explained why you singled out some but not others. That's completely unreasonable. And when they've applied a completely unreasonable standard, they've done not a terrible job. I'm not terribly enthusiastic about some of the things they've done, but they've been okay. On the other hand, when they've tried to examine justifications offered in detail, they've gotten into trouble. And the reason is that they haven't understood the degree of uncertainty that existed when the regulations were put in place and the need for doing something quickly. So what happens is the executive, in conditions of high uncertainty and necessity for quick action, impose a regulation. Because at the moment it looks like, given the information available and the best science available at the time, looks like the regulation is what's needed to halt or slow the spread of the virus. Sometime later, the courts come in and say, what were you doing then? And they evaluate 3 months later what the government did at the time. And they haven't been terribly sensitive to the uncertainties and the need for speed. So they've probably invalidated regulations more often than they should have. So again, executives have vindicated Schmidt's idea that somebody's going to have to do things that look extra legal, and courts haven't overall done a great job at explaining why the extra legal stuff is actually illegal. Okay. Now, third point, third section of my talk. It's an implication of Schmidt's analysis that executives are going to use emergencies as an occasion for expanding their pre-existing authority. And Schmidt said, and I think was largely correct, often those expansions of authority will be justified. There are various quotations from people. In the US, there's this famous statement by an advisor to President Obama saying, never let a good crisis go to waste. And it's a standard line in the literature on authoritarianism that authoritarian leaders love emergencies because they can use them as an occasion for expanding their power. And they can offer legal arguments, Schmittian, but legal arguments explaining why that makes sense. What's interesting about the COVID experience is that there are two extremely prominent examples of what's been called executive underreach rather than executive overreach. Executives who deliberately chose not to exercise or grab greater power in the emergency. That's Donald Trump in the United States and Jair Bolsonaro in Brazil. And I think there was a period, now you folks will know better than I about this, but I think there was a period when Prime Minister Modi also underreached, that is deliberately chose not to respond with expansive exercises of executive power. Now, I won't talk about Modi because I'm not as confident about the story as I am about Trump and Bolsonaro. There, it is clear that they made a deliberate decision not to exercise expansive executive power, even though both of them are typically described as populists who were in favor of expansive executive authority. Now, I should note, other conservative populist leaders did use the pandemic as an occasion for exercising expansive authority. So the question is, what's the story about Trump and Bolsonaro, or about the US and Brazil, that explains their executive underreach? And there's no systematic explanation available as yet. And it's particularly puzzling because, as I say, other conservative populists did use the pandemic as the occasion for exercising expansive authority. People come up with stories about why Trump and Bolsonaro didn't want to exercise expansive authority. They might be right, but you can come up with, if they had chosen to use executive authority, the same kind of story you could generate the same kind of story. So the Trump-Bolsonaro behavior is puzzling and will require more analysis over time. Finally, I do have a few minutes, so I'll take it to speculate about other institutional approaches. In the United States, and this actually connects to the Trump-Bolsonaro story in a particular kind of way. In the United States and elsewhere, critics of government policy responses have said the problem was that the government didn't follow the science. My own view is actually they were probably following the science as best they could under the circumstances, but criticism is they didn't follow the science. How is this connected to Trump and Bolsonaro? Well, one part of the story that are told about them is that Trump and Bolsonaro ran on populist platforms skeptical about elites, including scientific elites. So they were not going to follow the science because the science was in the hands of people who they opposed. Now, I'm not sure that that's an accurate story about Trump and Bolsonaro, but I do want to come back to the point about following the science. One of the things about the science is that it told you a lot about the pandemic, and it told you a lot about what you needed to do to control the spread, but the things it told you were economically very costly. And the science of the virus can't tell you how much cost you should incur to prevent the spread of the virus. It can tell you the things you can do to prevent the spread, and it can tell you, like, shut down your economy for a month, and you can calculate what that's going to cost. But except for extreme devotees of cost-benefit analysis who place values on human life and illness, science and economics, the science of economics, the science of the virus and the science of economics can't tell you whether you should actually shut down the economy or not. Okay, so We have a situation in which the science of the virus tells you some things. Economics tells you other things, and you've got to figure out what to do given those two things. Now, we have institutional structures in place to do that. They're, prime ministers and parliaments. And given the nature of the pandemic and the need for speed, that's what we had to use in 2020. By now, there might be other possible institutional responses. So what I have suggested is instead of asking experts about what the science tells us about the policy response, we should actually ask ordinary people. We could convene citizens' assemblies of various sorts to decide both policy, I'll do it in the strong version, to decide the policy to be applied in the first instance locally to control the pandemic, and eventually to decide the policy on a national level. I myself think that at this point, that is a year, more than a year, into the pandemic, it would be probably, I'll put it in a strong version, it might be probably a good idea to have a national referendum on what policy should be going forward. That somebody should come up with a proposed COVID-19 regulatory statute that the people of every country will have a chance to vote up or down. Because now I think we know enough. We don't have to respond quite so quickly, but and we know more. But the point I want to make with this is not to defend the referendum idea in general, but to note that there are sources of knowledge residing in ordinary people that are not well captured by our existing structures of decision making. And that things like citizens' assemblies or referendums might be useful at this point to supplement our existing methods of decision making. Okay, so those are my four propositions. I've talked for about 40 minutes, which was what I expected to do. And now I'm happy to entertain questions, challenges, responses based on the Indian experience specifically, and the like. So thank you.
Thank you, Professor Tushnet, for this lecture. I think, yes, Aswant has a question in the chat box.
I'll start. I see there's one question in the chat box already, and I meant to mention this and then either forgot or left it out for reasons of time. The question is, with regard to the executive underreach issue, if the courts intervened on account of executive underreach in making policy decisions, would it qualify as an act of usurpation of constitutional powers? What's interesting is that in Brazil, the Constitutional Court was very aggressive in forcing policy responses that Bolsonaro had refused to make. It required various actions to be taken. When Bolsonaro tried to stop state-level actions from occurring, the Constitutional Court said, no, the states have the authority here and they can do what they're trying to do, and was quite aggressive. The point where in some level Bolsonaro has eventually gone along with them. um, reluctantly, but gone along. Um, so there are two aspects of the Brazilian experience that are worth noting. One is that, well, one is that in traditional separation of powers terms, forcing the government to act is, I wouldn't say a usurpation of constitutional power, but rather an aggressive exercise of judicial authority in a system of separated powers. Now, that's occurred in other areas, including the enforcement of social and economic rights generally. And so constitutional systems are beginning to get used to the idea that courts can force executives to do things, quite expensive and significant things, but it's still relatively new on the scene. Um, okay, so it's a new development in the separation of powers. The second observation about Brazil is, and this may have some bearing on the Indian situation, Bolsonaro was at the time a year ago in an extremely weak political position. He had won a majority to become president under quite peculiar circumstances, but had, as most Brazilian presidents always have had, very little support personally in the parliament, in the legislature. The Brazilian system is described as presidential coalitionalism. So the president gets elected on a national basis and then has to stitch together a very complicated coalition to support his actions in the parliament, in the legislature. And Bolsonaro didn't have very much support in the legislature himself. He was able to put together a coalition, but lots of people in the coalition were not happy with his leadership. And so when the courts intervened, many of the parties in the Bolsonaro coalition were perfectly happy to see the courts, slap Bolsonaro around. Just as a footnote on this, on the Brazilian system, it's an anecdote, but it's really quite striking. In, I think it's 2012, 2013, the president was Dilma Rousseff. She won an election as president. She had to put together a coalition of support in the legislature. In order to do that, she had to offer the vice presidency to the head of an extremely conservative party. Her party was quite liberal. She had to offer the vice presidency to the head of this conservative party. He basically conspired to have her impeached so that he would become president. And that's what happened. He engineered a quasi-constitutional coup where the impeachment was based on essentially frivolous grounds, not completely frivolous, but essentially frivolous. And then he became president, and things went downhill from there. Okay, so yes, when courts intervene, it is an example of a new version of separation of powers. I wouldn't call it usurpation, it's just a new system.
Professor Tushnet, you argue that constitution limit the power of the decrees, but what we have seen during the pandemic is that the legislation governs through the not through the statute but through the decrees. So, do you think, and you argue that the difference lies in transparency? So, do you think that when there is an executive aggrandizement, the watchdog institutions or the The transparency remains the inherent difference between the governance by decrees or governance by the statute.
Uh, so I'm inclined to think that there's a small difference in this context between governance by decree and governance by statute. Um, the thought is that in these circumstances where action has to be taken, where the executive acts quickly, in my view, because it has to happen quickly, the exposure of the reasons for the action will be small. There'll be the government will issue a decree. It'll have some formal statement of justification for it, and then maybe 3 or 4 weeks later, there'll be some document produced that explains explains why the regulation was justified. In contrast with legislation, typically, although not always, there is some public discussion of the proposal. In parliamentary systems, there are first, in particular, second readings, where the second reading involves a reasonably detailed discussion of the proposal. But legislatures during the pandemic, we could see legislatures moving extremely quickly. So first, second, and third readings occurring within hours of each other. That's occurred in Hungary and in other places where Hungary's a problematic example because they're not really a constitutional system anymore. They're a fully authoritarian system. But other places, you also had very rapid legislation. So I think that in these circumstances, there might be a small difference between governance by decree, difference with respect to transparency between governance by decree and governance by legislation, but I don't think it's terribly large. Let's see, I see there are two. Yeah,
Yes,
go ahead.
there are
Sorry.
two. Yes, Professor. There are two questions in the chat box. So Yogesh is asking, generally there exists a defined line between rule of law and authoritarian constitution in normal times. Do you think that this line shifts or even ceases to exist in these extraordinary circumstances, considering the nature of decision at the disposal of the executive? Also, is there an objective test to ascertain the nature of the executive action if the line does not exist?
Okay, so I think this is where Schmidt was right. That is, we have to understand, the way I would put it is this. We have to understand the rule of law in quite thin terms, even in ordinary circumstances. And if we have an appropriately thin notion of the rule of law, publicity, prospectivity, with some narrow exceptions for retroactive action, and so on. I don't think that Schmidt's point was that with an appropriately narrow notion of the rule of law, we wouldn't have to distinguish between ordinary rule of law and extraordinary emergency conditions. I think that's right. I think it's better not to think of, not to frame criticisms of governmental overreach in emergency situations as violations of the rule of law. Rather, I think they should be framed, the criticisms should be framed as substantive disagreements with the policy choices that the government has made. Um, um, so, for example, in the United States, the Supreme Court has held that some of the restrictions on religious gatherings were violations of the right of religious liberty. Um, I think the way to deal with those policies is to say they are misguided, they're not adequately justified. Or, in contrast, to criticize the court for saying, for failing to take into account the nature of the emergency and so on. That is, the discussion should be at the level of particular policies rather than at the level of executive overreach, breach of the rule of law, or the like.
So, Professor, next question is from Sukhpreet. He is asking, sir, to what extent is a federal structure responsible for the lack of a unified national response and resultant mishandling of the pandemic in the USA? I ask this in light of the recent event of students from all over the country heading to Florida for spring break, where the authorities seem to have a lax response, not really enforcing preventing measures as much a state like California, which has leads to a surge in the number of cases among young people.
Um, so the nature of um, Trump's underreach was to leave the policy to the state level. As a matter of constitutional doctrine, there's essentially no problem. There would have been no problem in the United States with vigorous assertions of national power over individual behavior. Uh, um, there's some question about whether the national government could have, as a matter of existing constitutional doctrine, could have required everybody to wear a mask whenever they're in public. And President Biden has acted in a manner consistent with that constitutional concern. But, for example, it would have been trivial as a matter of US constitutional doctrine for the president to require, well, to do two things. First, in the short run, as an emergency measure, to require everybody who enters a business place or a government building to wear a mask and maintain what people are calling social distance. And then, second, to seek, as a matter of urgent national need, legislation to authorize that requirement. One of the tricky things about the US statutes, and this again is a Schmittian point, is that there are several provisions dealing with what federal agencies can do in response to emergencies, and none of them seem well suited to the mask requirement. That is, it's not clear that you could invoke any existing authorities to impose a mask requirement. But clearly, legislation could do that. And I think that had Trump wanted to do it, he could have gotten away with it. So it's not that the federal structure generated the underreach. It was that the federal structure was the form that underreach took in the United States. And I would note, I think, I'm less clear on this, but I think in Brazil, the underreach was Bolsonaro saying to states, you can't do things. So there, Brazil does have a federal structure, and the underreach did not flow from the federal structure. Again, I mentioned the Brazilian Constitutional Court stepped in and said, Bolsonaro, you can't stop the states from doing this stuff. So the federalism was the solution to the problem in Brazil, whereas it was the source of the problem in the US.
Professor Tushnet, my next question is that do you think the pandemic has discouraged the discourse on positive constitutionalism? What Nick Berger argues that the constitutionalism must create the competent state institutions. So, do you think we have failed to create a discourse on a positive constitutionalism all across the globe, and instead it shifted to the idea of negative constitutionalism?
Yeah, so I do think that the pandemic experience has exposed some gaps or incompleteness in, in constitutional theory. My own view is that it's not in connection with negative and positive constitutionalism, because I think that the ideas of social and economic, constitutionalized social and economic rights have pervaded widely enough that the negative versus positive constitutionalism debate is well explored. People disagree about the outcome, but the lines of discussion are pretty clear. I think that's less true of emergency power, and the reason I think is pretty straightforward. The experience with international terrorism that in the United States is captured by the word September 11th did produce a vigorous policy response that triggered notions of emergency constitutionalism and a great deal of concern about abuse of power in the circumstances of anti-terrorism legislation, understood as emergency legislation. And so in the, call it, decade after September 11th, so by, say, 2010, a decade ago, constitutional theorizing had become extremely suspicious about exercises of emergency power. And along comes the pandemic, and it turns out that, you know, maybe there's something to be said in favor of expansive executive authority in emergency situations. And so we today have a discourse of emergency powers that was shaped by the response to terrorism experience, where there rightly was a great deal of suspicion of abuse of power. But that discourse seems to me inappropriate, or I don't know, not needs to become more nuanced in light of the pandemic experience.
Is there any more questions? So, thank you, Professor. I think we don't have any more questions. I thank you on behalf of Constitutional Law Society. I thank University Administration for facilitating this discussion. I thank our faculty advisors, Professor V.D. Singh, he is here, and respective fellow colleagues and the members of the Constitutional Law Society. I thank participants also to join this Sunday evening. We thank you, Professor this Sunday morning goes to allot the 1 hour first, and we hope to host you someday in India physically.
Thank you very much.
Thank you, Professor.